TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching the miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation, and you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
Mr. Cotton.
Good morning, Your Honor. Your Honor, I'm Byron Cotton for the record. I'm here on behalf of Melanie Austin. Judge, I'm not sure if she's currently on your docket.
I understood that it was removed.
That was the way it appeared, but I wanted to address something with the court just in case.
Sure.
If we could just build a small record. There was a written plea filed in this case.
Correct.
It was filed because we're in felony court on a felony form. That does not provide for an order for the court to enter.
Right.
She pled actually originally 2 misdemeanors, and it's a VOP misdemeanor.
Right.
I was hoping we could do a minute sheet on that order today. I'm sorry, on that motion today, because she's got 60 days credit for time served, and she's 61 today, I believe. So with that, or I'll provide an order to the court. Anything I can do, I just want to make sure we've documented. The court hasn't been able to enter an order on that plea agreement yet. Because
okay, I thought it was entered already. No?
There's no signature on the felony plea agreement is the problem. That's the reason why I came today. Because
you got something for me?
I will have something for you, Judge. I can send that to you or come back to the court with it.
Yeah, do it as a written plea and abstention, basically, or do an order.
I'll just provide an order on the motion that's already filed.
Okay.
I mean, the plea agreement that's
Yeah,
already
just
filed.
make sure and get it and follow up with my office, make sure it gets signed, you know,
I'll have it to you this
she needs to
morning.
get out, she needs, you know.
Perfect.
Get her out.
Thank you, Judge.
Thank
That's
you.
all I've got.
Thank you, Mr. Cox. Ms. Reed?
Hi, good morning, Judge.
Good morning.
I have one case on the court's docket. I'm covering for Mr. Mike Gates, and that is Curtis Jarrett, 22 CF 2424.
Hold on just a second.
Okay?
Okay. You may proceed.
Okay, thank you, Judge. Your Honor, we are here on a motion to early terminate Mr. Jarrett's supervision. The conditions of his plea agreement were to pay restitution, complete the shoplifter's awareness course, and pay court costs, and then his supervision would be automatically terminated. Those items had been paid and completed sometime in early to late February, I believe. There was a technical violation for a positive UA. However, the technical violation letter sent to the court and the recommendation from probation was to have no other punitive action, but just continue to supervise. I did have a conversation with probation this morning, and they have agreed that they are okay with the early termination request from the defense. They would waive any cost of supervision and any arrears, and all Mr. Jarrett owes is a $35 drug testing fee. And then once that is paid, probation would be terminated. I have talked to Mr. Hearn with the state, and I don't believe there is an objection from the state either.
Counsel?
That's correct, Your Honor.
Very good. Without objection, the court will grant the motion to terminate probation immediately.
Okay, thank you, Judge.
Can you
That's
give
all I
me an
have
order?
before the court. May I be excused?
You may. Thank
Thank
you.
you.
Have a good
You guys
day.
have a good day.
Mr. Shaw?
Good morning, Judge. Tim Shaw for Micah Hagan. That's in 19 CF 423.
Hold on just a sec. Okay, go ahead.
Judge, you're bringing Mr. Hagan out right now. Judge, again, Tim Shaw from Micah Hagan, 19 CF 423. I have provided some reciprocal discovery to the state, and I believe the state has an announcement.
The state's going to no process case.
Very good.
Thank you, Your
Court will
Honor.
accept the null pros. Release the defendant. Thank
We
you.
will. Thank you, Judge.
Okay,
That's all I have today.
thank you.
Judge, I didn't have my name on the list.
That's all right, come on up.
Judge, I've
Thank
got
you for,
Britton Cole, Eisenhower, 21 CF 483, may I approach?
you may. Thank you.
Judge, Mr. Eisenhut's going to admit that he violated his probation. The agreed upon sentence is that the court would revoke and terminate his current term of probation and put him on 6 months community control. He'd be adjudicated guilty, and then I guess there'd be a $100 BOP fee or what have you.
Very good. Would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
Is the state in agreement?
Yes, Your Honor, that is the state's agreement, Your Honor. And I will owe the court a score sheet on this. His total sentence points are 14.10, and I will submit that to the court later if that's okay with Mr. Knowles.
That's fine.
Very good. So, Mr. Eisen, I just have to ask you a few questions. You understand that by entering this plea agreement on this violation, this is the final resolution of your case. You do have a right to go to a hearing. You can test all this. You're waiving all that. You believe this is in your best interest to do this?
Yes, sir.
Okay. You've had all your legal questions answered by your attorney?
Yes, sir.
Okay. Based upon that testimony, the court will accept the plea agreement. The court will terminate and revoke probation, sentence you to 6 months community control. You understand there's increased, I don't really like the term community control. I like the term house arrest, because that's better description. You willing to, Bob, you understand how it kind of works. It's probation, it's community control, and then it's Yeah, they're going to be asking to, do time, and I don't want that. Let's get this done and get straight with it, okay? Thank you very much. Count, I'm sorry.
Your Honor, I spoke with the individual's probation officer.
Yes,
She
sir.
asked that his COS and all arrearages be waived due to the short time in which he's going to be remaining on probation, and given the low amount of money that he currently makes.
The court will waive the cost of supervision.
In the back, I think there's.
Yeah, and then and waive the past cost of supervision as well. Okay.
Very good.
Okay, thank you very much. Mr. Stewart.
Good morning, Your Honor.
Good morning.
May it please the Court, Brad Stewart, on behalf of Joseph Bednarik III, Judge, this is 22 CF 2023. If I may pause for a moment as Mr. Bednarik is retrieved, he is incarcerated.
I don't have you on here, and they list them according to attorney, so.
Judge, I believe we recently filed either Monday morning or late Friday.
Is it not on here?
Yes, it is.
Yes.
If you will check in on Laura,
And Ryan Marshall, Mr. Bednarik, he was on our docket for me this morning, Your Honor.
Bednarik?
Your Honor, I have him as number 9 on this morning's docket, and the docket that I have has Mr. Stewart as
Yeah,
his
I
attorney.
understand. I don't have that updated one, so. Okay. So I've got Joseph Bednarik, 22 CF 2023.
That's correct, Your Honor.
You may proceed. I've got it as a written plea agreement.
Judge, we just came on, so if we could continue this matter so I can get up to speed with Mr. Bednarik.
Okay. So there's not a plea agreement on this already?
He might have filed a written plea of not guilty.
Not guilty.
Not guilty.
Very good. Okay. So not guilty plea has been written, and we'll come back. You want to come back on next miscellaneous, or go to?
If we can, Judge, yes.
Okay. Do you have a list of dates for me? Sorry. Pardon?
Your Honor, the next miscellaneous date we
Thank you.
have is next Tuesday, I think, so
Wait a sec. Wait.
you may want to go out for it.
So we've got a week from today. May 16th, is that too soon? May 16th?
The DOP discovery's already been sent, if you want me to make sure it gets.
Judge, let's leave that there for status and see if we can't figure something out.
Okay. We'll come back on May 16th in the morning
Very good?
without subpoenas.
Yes, please. Your Honor, that's all I have. May I be excused?
You may. Thank you.
Your Honor.
Is Michael Bailey here? Yes, Your Honor. If you'll come forward. Just come up to the podium. There's several people. Mr. Bailey's one of them that doesn't have an attorney, so for those of you, there's several others that are in the same situation. You do have a right. We'll see. Let me announce your case. 21 CF 485. Excuse me. 495. You do have a right to have an attorney appointed. However, I don't know if the state's just to make. Is there an offer on the table?
Your Honor, I'm sorry, I missed the name.
Bailey, Michael Bailey.
Your Honor, I'm sorry, give me just a second.
If you do wish to have an attorney appointed, depending on what they say, what we'll do is we'll appoint you an attorney. You still have to fill out the forms and make sure you qualify. but we'll enter a plea of not guilty, excuse me. In this case, it'll be a denial of a violation, and then have you come back and you can talk to your attorney before you do that. State?
Yes, Your Honor. The state's offer for this violation is to revoke and terminate and incarceration, so.
Okay, so let's go ahead. Generally speaking, if they're seeking incarceration, you need to talk to your attorney. So Mr. Morrow is here. You wish to have an attorney appointed. I assume you do, Mr. Bailey. I'm doing all the talking, you're not talking.
Yes, sir.
Mr. Bailey, you wish to have an attorney appointed?
Yes, Your Honor. Okay.
So court will appoint the public defender. Mr. Morrow is the specialist in this area.
I've handed
And
Mr.
we'll-
Bailey a card, Your Honor, and we'll enter a denial if that hasn't already been done for the record.
Yes. Court will enter a denial and we'll come back. June 15th, is that a good?
That'd be fine, Your Honor.
Okay. We'll come back June 15th in the morning. Okay. Jarrett Lee Dawson. Joe, you here?
Thank you, Your Honor.
Thank you. State?
Your Honor,
Jarrett Lee Dawson.
I don't see Mr. Dawson approaching the podium.
He's not.
I would request a case, please.
Or issue a no bond capias. Okay. Mr. Harper here? You want
I did see him, Your Honor.
you want to do some of yours? You're the only one standing, Mr. Morrow. So
That's fine, Your Honor. I was just ready to hand out some cards. I can call you from the gallery.
okay.
Call me Holly Snowden. Ryan Morrow from the Snowden, Your Honor. This is 19 CF 1894. We're here having already been evaluated, I think, for Keaton and drug court. There's one other program that I'd like to have her evaluated for. Before we resolve the case, I'm asking the court to allow me to continue this that June 15th date.
Okay. Very good. We'll continue this to June 15th. Is that okay with the state?
It is, Your Honor.
Very
What was the
good.
date?
June 15th,
Thank you.
without subpoenas in the morning, 9 a.m.
Mr. Derek Jutros.
I'm sorry?
Jutros with a J, Your Honor.
J.
J-U. Your Honor, this has been passed for a Keaton evaluation, and we had an issue with the paperwork. I'm asking for another continuance to get him evaluated for the Keaton program.
We'll come back in June, same thing?
Yes, sir.
State okay with that?
Yes, Your Honor.
Continue it to June 15th, 9 a.m.
Next, I'll call Christopher Wilson.
You got to say it clearly because I'm having to track from that onto my docket.
That's
so.
Christopher Wilson, Your Honor.
We're not going down the line. I'm having to go through
You're
about
right,
20
Your Honor, I'm
cases.
sorry.
What is it?
Wilson.
Wilson.
It's 21 CF 860.
Very good.
We're asking the court to allow us to continue this to 6:15. This will be a pass to complete is the desire here, Your Honor. And Mr. Wilson did come in with some indications that a lot of this stuff has been done.
That's correct, Your Honor.
Okay. So we'll continue this to June 16th. Excuse me, June 15th at 9 a.m. Just seeing if you're paying attention. We can go with the inmates too if you need to, Mr. Morrow.
I can, Your Honor.
We'll
If
just
we
start.
want to go alphabetical, if that makes
Sure.
sense, I'll call Mr. Hard. ARD, Your Honor. I think on the docket, it's
I think
under Mr.
ARD
Medina.
was, let's see. I don't have ARD. I do not have, unless somebody can tell me where it's at in the docket, I don't have an ARD.
I have page 9, Your Honor, but I'm not sure I'm the same version of your docket.
Is this like a new,
No, Your Honor, it's a VOP, and it was originally under Mr. Medina.
okay, that's why it's not, these are under attorneys, they're not under the, so, okay, now I'll find it then.
Ryan Morrow for Mr. Ard, Your Honor. I've just been presented with the state's offer. They're seeking to impose a suspended sentence in this case. I'd like an opportunity to sit down with Mr. Ard and discuss whether this is going to be a contested hearing or a plea to the court.
Okay. Do you want, how long will it need? We've got May 6th. How many do we have on May 16th in the morning? And
The 16th would be fine, Your Honor, for that
only
purpose.
a week. How many do we have? Hold on a second, just make sure.
Certainly.
Okay, we'll do that. We'll do it. We'll continue it until May 16th at 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
No. This is without subpoenas. This is just another continuation. If it'll be set if it's not at that time if the plea is not accepted.
And for the record, I believe that's a denial.
Hold on a second, Mr. Morrow.
Yes, Your Honor.
Is that a denial, Mr. Morrow?
Yes, if that's not already on the record, we would enter in denial if that was his first time up, Your Honor. I
Correct.
apologize.
Thank you, it was.
Thank you.
Ryan, is that yours, sir?
Yeah, thank you.
Do you have a couple? Can I?
Yeah, go ahead.
Your Honor, I had a couple of continuances, if I may.
Okay.
Steve Medina for Brittany M. Cinco. Ms. Cinco is approaching, Your Honor, in 22 CF 1279. I could try to get my docket number.
Very good, I got it.
Thank you. Your Honor, Ms. Cinco's husband has a case represented by Jay Patel. My conversation with the state indicates that we probably need to continue Ms. Cinco's case because there may be a resolution in the other case.
Okay.
If we could...
Do you want to come back on the May 16th or go out and the next one after that would be June 15th? Actually, we have
Probably June 12th, Your Honor.
How about June 15th? We don't have June 12th.
Well, Your Honor, this
That should
is
be
not a BOP. We were trying to get a resolution. This is a
This is not a BOP? Okay.
No, Your Honor, it's a new law. It was more or less
That's
put on
fine.
miscellaneous because we were hoping for...
That's all right. We'll come back then on the regular pretrial on June 12th.
Thank you, Your Honor.
Okay. We'll continue to June 12th in the morning at 9 a.m.
Thank you, Your Honor.
Okay. Thank you.
Your Honor, a man called Jerry D. Mays. Mr.
Okay.
Mays is approaching in 21 CF 1932.
That's what I was going to ask about. Your Honor, in Mr. Mays' case, I believe the violation is based solely on a misdemeanor that was null prost, so we'd withdraw the VOP. And he remains on probation with all original terms and conditions, sir.
Okay. Did you hear what she said? So the violation is being withdrawn, but you are still on probation, just like you were, all the same terms and conditions. Make sure and stay in good contact with your probation officer, okay?
Yes, sir.
Question?
No.
Okay, I just wanted to make sure you didn't have any questions. He looked like he may have had some questions, but anything you need, you can follow up with your attorney.
Thank you, Your Honor.
Okay,
I'm sorry,
thank you.
I didn't mean to.
That's
cut
all
in.
right.
just
I know
wanted
you're
to
trying
make
to
sure
protect your
we didn't,
trying to protect your attorney,
Yes,
your
sir.
client.
Thank you. Take care.
This defendant was actually arrested on a VOP. Can I state VOP dismissed? Is that okay?
I think that was the intent. was it?
Yes.
Okay,
Yes.
I just wanted to be sure I can put that in the systems.
Thank you.
Doesn't allow us for a withdrawal.
Gotcha. Mr. Medina, what's your next case?
Your Honor, I have one that has shown up from the afternoon docket. We'd like to address it.
Okay.
Mr. Brown,
Which docket?
the afternoon contested hearing docket, I suppose would be your 2:30 docket.
Okay.
And that was Mr. Donald Frazier. The state has filed a motion to continue that matter. They didn't have my position at the time, but I let your judicial assistant know that I did not object for a separate reason.
Yeah, I did see there was a motion to continue, but it was, well, it's this day, I don't know. Hold on a second, let me. So this is a state continuance.
Your Honor, I believe it was, we spoke before the hearing, and it was going to be stipulated to, he did email your
Okay, that's
secretary.
all right, but I just didn't, I didn't get a final resolution of it. That's fine, I'll allow the continuance.
Thank you.
Okay, very good. Court will continue this. Where are we continuing it to?
Your Honor, I believe the date that I requested is in the motion. I think it was mid-June due to the officer being out on extended leave.
Okay, hold on a sec. Make sure we get that. So you want June 15th or June 20th?
June 20th would be best.
Okay, and this will be in the afternoon for a contested hearing.
Thank you.
And about how long do you anticipate it?
Short hearing, Your Honor, less than an hour.
Okay, very good. So we'll do it on the June 20th.
And the hope
Continue
will be
this to
that,
June
that
20th.
we won't need to have that hearing.
I'm sorry?
Mr. Frazier is doing his best to attain compliance before that hearing occurs, so.
Okay.
Your Honor, can I want to go do the drug evaluation at Bridgeway, but I need a referral from you because the probation, I'm not on probation anymore. So they won't have anything to do with me.
I had advised Mr. Frazier to give it another shot and that I would get involved with probation if need be. I don't know if he needs an order from the court.
Just stay in contact with your attorney. If it's not able to be resolved, there's some that needs to come from me, I'll be glad to sign it. Okay? But just check with you. You should be able to get it without some coming from me, but if anything needs to be done for the court, we'll do it, okay?
Okay.
Okay.
Thank you.
Thank you, Your Honor.
All right. Thank you.
Okay, thank you. Mr. Patel, you want to?
Yes, sir.
You got your.
Good morning, Judge. Jay Patel on behalf of Lawrence Cinco. Judge, this case was set for today, albeit a placeholder status so we could understand kind of the direction of the prosecution. In having an extensive conversation over the last few days with Ms. Sharpless, I'm seemingly beginning to understand a little bit as to the nature of their position. As such, I know Mr. Medina represents my client's wife in a companion case that was set for the 12th of next month. I think that that's appropriate. I'm going to need to set up depositions, and we're likely going to continue it from there, but it seems that there's a fair amount of bank statements and things of that nature that haven't been provided to me, so we're pedal to the metal.
Okay, so we'll just continue, move it back onto the regular cycle pretrial on 6/12?
Yes, Judge.
Is that good with the state?
Yes, Your Honor, that was what I anticipated.
Okay, very good.
I have nothing further. May I be excused?
Right.
Thank
Thank you.
you.
Who wants to run? Mr. Medina, or Mr.
Your Honor, my only other out of custody at the moment that I'm aware of who's present is Mr. Kabbalah, but the state needed to contact the alleged victim. We may have a misdemeanor plea agreement, but the state needed a little more time. We're hoping to get it done by 1:30 this afternoon.
Okay, so you want to pass this until 1:30?
If that's possible, Your Honor.
What is the name?
That's Jerry T. Kabbalah, Caballa, 23 CF293, and he is present. And I'll just let him know to come back at 1:30.
Okay.
Okay, so you're just going to come back at 1:30. You can stay here. Okay.
Derek Jones, or Sonia Greco.
You want to
I
just
think
do the
rest of mine
inmates?
I think the rest of mine may be in custody, Your Honor.
Okay, that's
What's your
fine.
name, sir?
Harris Brown.
Okay, one moment, Your Honor.
There may be some unrepresented. I don't know about that, Your Honor. Mine are all in custody.
Okay. So,
Your Honor.
so what is your name?
Jerome Dito.
Come forward.
My name's Jerome Dito.
How do you spell that?
Last name.
Spell your last name.
Dito, D-E-D-E-A-U-X.
Who's your attorney? Who is your attorney?
I didn't have an attorney. This is,
Do you have a case number?
yes, sir.
What is your case number? We're trying to find it on our docket.
Case number is 0CS023 CA.
Okay, you're in the wrong court.
I'll let him know you. All right, thanks. Sorry about that.
It's all right. Okay. You on a roll? Mr.
Inmates,
Case?
Your Honor, I can. I know that
I mean, I'm willing to go, whatever.
I'll let court security go. I think Mr. Harper's meeting with some inmates, and then Mr. Stewart's. You just want to take the inmates? They all could be with Mr. Harper.
I have Mr. Kendall now, Your Honor. I can take Mr. Kendall, I see. Ms. Sharpless, can we do Mr. Kendall now? Joshua? I think so, but I'm gonna have, it's probably gonna need to think it over and meet with me. Your Honor, Steve Medina with Joshua T. Kendall, 21 CF 2175 and 22 CF 1736. We had motions to compel that were pending for today.
Correct.
I would ask for the court to allow us to continue those to June 12, or just continue him to June 12. We have a probation offer from the state, so it's not going to involve jail. We know he's not getting into mental health court, and he can't do drug court. So we hope to work it out on June 12th. We now have what Ms. Sharpless believes is all the discovery. So rather than have a disposition on the motions to compel, I will in good faith expeditiously review that. He can set an appointment right away to go over the video and so forth and make sure he knows what the facts are and allegations and so forth.
So we'll just come back on a regular pretrial cycle June 12th?
I think that would be appropriate, Your Honor. If that's okay with Madam Clerk as far as the system goes, I don't think we need an order on the motions to compel. We'll just study up on that.
Yeah, we'll just let it lie right now.
Yes, Your Honor. Thank you.
So we'll continue this case until June 12th at 9 a.m., okay? Stay in touch with your attorney in the interim.
All right, that's right. Set up an appointment right away. Okay, thank you. Thank you, Your Honor. My other clients that are present are incarcerated, Your Honor. I'm ready for them whenever. Thank you. The first one would be Michael A. Bennett. The other one would be Mr. Sanford A. Burgess. Thank you. Your Honor, Steve Medina with Michael A. Bennett and 20 CF 1937. The state has a guidelines prison offer. I think at this point in time, he needs to enter a denial. And my understanding is that he is intending to oppose the paraphernalia that is the sole basis for the violation that's in misdemeanor court. So if we could continue this to June 14th, well, I guess June 15th or whatever the miscellaneous date would be.
Well, the miscellaneous date would be June 15th.
That would probably be appropriate, Your Honor, because this is...
You want to still come in the morning? We're still not doing subpoenas, we're not...
Yes, just without subpoenas, Your Honor.
Okay.
Morning is good.
Okay.
So maybe you'll resolve that.
So June 15th in the morning at 9 a.m.
And I'm also going to be getting him some information, and he's going to be trying to get some information too. So we'll be talking some more before June 15th.
Thank you.
Thank you, Your Honor.
You can line them up in alphabetical there, bud.
I don't know. I don't have any information on those clients, sir. But whatever you deem appropriate, but I don't have any file on them.
Okay, then disregard. I thought they were yours.
They may be eventually. This is Mr. Burgess coming up next. Your Honor, Sanford A. Burgess II is before the court. Mr. Burgess is 23 CF 654. We're here on a bond motion, Your Honor.
Hold on just a second.
Yes, Your Honor.
Okay.
Your Honor, Mr. Burgess is here on a request for a signature bond, or at least as much as possible a reduction into $20,000 cash or professional. He does represent some facts to me that I wanted to tell the court that this appears to be a situation where there's definitely going to be another side to the story other than the alleged victim. Mr. Burgess apparently drove the victim, got paid to get the victim's medicine and get him out of the hospital to transport him on the way to Panama City. Apparently the $100 taken, Mr. Burgess's position would be that it would be Mr. Burgess's $100 that was wrongfully taken by the alleged victim. So this is going to be a situation where I'm going to inquire with our investigator as to whether we will be able to conduct a deposition in all likelihood of the alleged victim. There is an address in the state's discovery exhibit, but it may be that he's going to be difficult to get to show for a deposition. We may end up doing a speedy trial demand, but right now we're just going to ask to proceed on the bond motion, Your Honor. I'm sorry.
I was just asking. I was going to ask when you're finished. I was going to ask the state to respond.
I think that's it.
Who's handling this, Mr.
Yeah, it's my case, Your Honor. The victim is unable to be here today, but I'm comfortable proceeding without them. I would like to respond to what's in the motion when it's appropriate, if this is the appropriate time.
You can. I mean, the fact that there's contesting the facts isn't really particularly germane to a bond hearing. I mean, it is in an ancillary way, but I'm more interested in the state's. Listen up, Mr. Medina. Listen to what I'm saying if you want to hear what I'm saying.
Yes, of course.
I'm more interested in understanding what is the basis, what is the basis that the state wishes to not reduce. In other words, why is the state wanting this?
Your Honor.
I'm not saying it's excessive, but it's a bond that's out of reach.
Yes, Your Honor. So the state would oppose any reduction in bond. Looking at the score sheet, he has a prior robbery, he has a prior grand theft, he has a prior burglary, and the score sheet that I have has him failing to appear or being convicted of failure to appear for a misdemeanor 5 times. And, Your Honor, he also had to be extradited here, Your Honor, so I do believe he's a flight risk. He does have a history of violence and theft charges, Your Honor. I would ask the bond remain the same.
Mr. Medina, you may respond.
Your Honor, I'm gonna, he has told me that he would be able to post a bond of 10,000 cash or professional instead of 20,000. So rather than asking for an ROR or a signature bond, we would ask for a 10,000 cash or professional. And do you have anything you wish to talk about your, whether you have any failures to appear without talking about the current facts or allegations?
Well, I'm not aware that I had ever had failure to appear. I was always arrested. I never bonded out.
What do you intend? There may be a misunderstanding about where your residence it will be if you bond out. Are you going to be here?
In Niceville.
You're going to be in Niceville.
Yes.
Do you have any residence there now, or do you just know you have?
I have a place to stay there.
Okay.
And I was.
So would the state respond as to whether they would accept a $10,000 cash profession? That's number one. And number two, would you respond to the defendant basically saying that he doesn't believe he has any failures to appear?
Your Honor, based on his history, I do not believe $10,000 cash or professional is appropriate. And Your Honor, I did the score sheet myself. I did check it. I do believe that's correct, but I will.
Where were the failures to appear?
For misdemeanor offenses, they
here
were
locally in Okaloosa. I mean, it doesn't matter really.
I
you
don't.
confirmed that you saw those failures to appear?
Yes, Your Honor, I did the score sheet.
Court's going to deny the motion based upon the history and based upon the failures to appear. I mean, if you can have your attorney, if he contests that, and, you know, I'm sure Ms. Sharpless will provide that to him, and if what you're saying is true, we'll see. But
I will get the certified copy as if we're contesting.
Okay, very good. Thank you.
Your Honor, he's scheduled to come back on May 16 for arraignment. May I have just a moment with him about whether?
Sure.
Your Honor, what he would like to do would be to waive arraignment that's currently scheduled for May 16 and go ahead and enter a plea of not guilty now, so he doesn't have to come back in a week, if that's okay. We do have an information.
Is the arraignment a felony? Is it on this case?
Yes, Your Honor, and
okay.
there is an information filed.
Okay. Well, if you wish to make a plea today, that's fine. We'll accept a plea.
So we just do a plea of not guilty today, Your Honor.
Sure. And so we'll come back. We're going to come back on this cycle, the June 14th?
Yes, Your Honor.
Okay.
And then I'm going to look into whether we feel it might be productive to try to schedule a deposition in the interim.
Very good. So we'll continue it until June 14th at 9 a.m.
Right.
And enter a not guilty plea at this point.
Right.
Is that okay, Madam Clerk?
And just on the record, if the state has any additional contact information, such as the victim is comfortable giving a phone number, then I may be able to do a verbal conversation and skip a deposition, as long as I can do my due diligence.
Okay. Very good.
Thank you, Your Honor.
Do Tyler Merritt. That's one of yours, Mr. Medina, in custody.
I need to reach out to my assistant to make sure to call him. He may be somewhere else at the moment, but he is not here. I'd rather not do a case.
I understand what you're saying. That's fine. Which case do you want to do next? Okay. Yeah, as soon as he can. Okay. I'm ready.
I'll call Harris Brown.
Okay.
His two matters before the court this morning, Your Honor. They're both VOPs, 21 CF 2765 and 21 CF 1914. We've entered a negotiated plea with the state that contemplates we'll be asking the court to revoke and terminate the supervision, all financials to reduce to a lien, $100 VOP fee for each case, $150 cost of defense for each case, and all outstanding DUI requirements to be D6'd. I'll pause and give Mr. Brown an opportunity to sign. And these were all pled down to misdemeanors, Your Honor. There will be no score sheet.
That is the state's agreement, Your Honor, and there is no score sheet.
Very good.
May I approach?
You may.
Thank you.
Okay, Mr. Brown, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I do, Your Honor.
Okay. So, you're entering an admission to the violation, correct?
Yes, Your Honor.
With the understanding that the probation will be revoked and terminated at this point, so you'll be finished with your probation. All the finances would go to a lien, some additional costs that are what is your reference to the DUI requirements, the D6
He is
requirements?
still finishing out some of those things, Your Honor.
So but I don't understand what is the agreement here in this agreement? You're just referencing it. I'm not following.
The issue is that they can't be waived. They're required by statute. He's still going to have to get those things done no matter what.
To get his license back from DSHMB, Your Honor.
Okay.
Yes.
So he's not under supervision, but he still has additional requirements to be made.
Right.
So the only effect it really has is he's not going to be. He has to finish those in order to get his license back.
Right.
Other than that, it really doesn't have an impact. In other words, he can't be picked up 2 months from now because he didn't do these, right?
No.
Correct.
Okay.
So he has.
I just want to be clear, so he's clear, so that, and I'm clear about what we're agreeing to here.
Say
again. What is?
Because if the clerk D6 then he's going to have a suspension from the court. If you ask the clerk to D6, if the
What is the D6?
It's a DMV thing.
How long is it going to take you to finish the DUI requirements?
Technically, I've completed the DUI course, Your Honor, and the substance abuse evaluation, Your Honor. I'm just in the substance abuse course now.
Okay. How long is it going to take you to complete that?
7 more weeks, Your Honor. 7 more appointments weekly.
So, I was going to say to come back, but I mean, I know you want to get this.
I'm fine with that, Your Honor. If the state is okay with that, I think it would be better for Mr. Brown.
Say that again.
When he completes his DUI school and all the requirements, he can then take his completion certificate to DHS&D. Then they will allow him to pay the reinstatement fee on the DUI and get his license back.
Right.
It's their own requirements.
Okay. All I'm trying to do is to be clear about what we're doing here today so that it doesn't adversely affect your client and he can get his license. So you guys tell me. I'm willing to accept this here today, but clerk is kind of going above and beyond. She's laying out the possible issue that would adversely affect your client.
May I have a moment, Your Honor?
Sure. Take your time. Thank you.
He's fine with go ahead and court accepting the plea today, Your Honor, and dealing with the D6 as it comes, is what he's asserted to me. I did explain to him the D6 situation in the vestibule before we came onto the record, and that those things would have to get done before he had a clear license.
Okay. Somebody needs to put this in here that not just a reference to it. You got to say, what is the agreement? What is being agreed to? I'm not clear about that in that reference. You make a reference to it, but you don't say what it is you're agreeing to. This is an agreement. What is he agreeing to?
He is agreeing that the outstanding DUI requirements, namely, I suppose in this case, the treatment component of the substance abuse evaluation and treatment will be D6'd.
Okay. Put in there will be D6. State's okay with it?
Yes, Your Honor, that's our understanding, is if we revoke and terminate someone from probation and they're on probation for a DUI, if the requirements are not completed within probation, then DHSMB will take over it, and those requirements still need to be completed in order for him to get his license back.
Yes.
So this is something that would happen anyways.
I agree. I'm not sure you guys are getting to where you want to go. Clerk's telling you that you're not getting to where you want to go, but that's all right. You want it. You're clear about it. You've been consulted by your attorney, and I'm okay with it. So you understand you've talked about the legal consequences of this plea agreement here today with your attorney. You feel like you got all your legal questions answered?
Yes, Your Honor.
Okay, and you're comfortable with it?
Yes,
You
Your Honor.
understand this is the final resolution, you're waiving your rights to go to a hearing and all that?
I do, Your Honor. I
Okay,
understand.
very good. Based upon that, the court will accept your plea agreement, revoke and terminate supervision with the fees and costs, additional being added, and as well as the continued DUI requirements being D6. Okay? Thank you.
Thank
Good
you,
luck.
Your Honor.
Mr. Harper, you want to do yours? You want to do your clients?
Let's start with Brian Brown, he's number 13 on the docket. He's before the courts on 22 CF 511. At this time, he's going to admit the violation of probation, and it will be an adjudication of guilt, revoke and terminate his supervision, assess all applicable court costs, and he's asking that those costs go to judgment. I'm just advising the court that I believe that Mr. Brown is on a number of medications.
Very good. Mr. Brown, would you please raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God? I do. Okay. So you heard your attorney state the terms of your plea agreement.
Yes, sir.
Did you understand that? Do you understand what he was saying?
Yes, sir.
Have you been able to talk with him about this plea agreement to make sure you understand it?
I fully understand it.
Okay. Now, he did make some reference, and I'm not going to be asking a lot of personal questions, but he just said you were on some medication.
Yes, sir.
I just want to make sure that those medications, that you're alert and that you can have a clear conversation with your attorney, and that those medications aren't affecting your ability to make a good decision on this.
Yes, sir. Yes, sir. I just want to get my up-to-date medicine.
Okay. Okay. But you're okay. You seem alert and clear-eyed, so I just wanted to make sure that you're comfortable entering into this, because we can put this off for a few weeks if we need to, but we'll get it resolved today if that's what you want to do.
Yes, sir.
Okay. And you understand that by entering into this plea agreement, it'll be a final resolution, no trial, and this will be done with. Do you understand?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will, there'll be an adjudication of guilt. The court will accept the plea agreement Court will revoke and terminate supervision, and then all the costs and the fees will go to judgment, okay? So
All right,
your
thank you.
probation will be finished today.
All right, thank you, Honor.
Okay, thank you. Jeffrey Brown, you want to just go down the line?
Sure, Judge, if that's fine. He's an inmate.
Yep, he is.
Rudy, I have an out of custody. Should I do an out of custody that showed, Your Honor?
Sure.
Mr. Merritt, Tyler Merritt. Your Honor, Tyler Merritt is before the court in 21 CF 2937 and 22 CF 2894. We have a motion to compel in 21 CF 2937. The state notified me late yesterday that the search warrants that are part of our motion to compel are still sealed, that body cam video and reports are being compiled now, that there's some lab results from DEA are more or less pending in terms of providing to us. There were no fingerprint or DNA. Long story short, it sounds like the state may want to go ahead and allow the motion to compel be granted with a reasonable period of time to provide information, or does the state intend to oppose the motion to compel?
It will take me some time. There was some overlap between state and federal jurisdiction, so it will take me some time, but I believe that our local field officers are willing to provide the information as long as we can get it from the DEA. So I do not oppose the motion. If
Your
I can
Honor,
have like a month to give it, though, it's going to be a while.
I was going to suggest that, Your Honor, that we give the state 30 days. That would be a few days prior to next pretrial, and hopefully we could have
Very
a
good.
moment
The court,
to review it.
without opposition, the court will grant the motion to compel and will order the providing of these documents that are contained in the motion to compel, and we'll give the state 30 days to do so.
Thank you, Your Honor.
And if you'll get me an order on that, I'd appreciate it. Mr.
Yes, Your Honor, I apologize. I don't have
That's
it.
all right. That's all right.
And then
Just get it to me.
it'll be just continued to June 12th then.
And we'll continue the case until June 12th. That's correct.
Okay, both cases. Thank you, Your Honor.
Thank you.
Judge, this is Jeffrey Brown. He's before the court on 22 CF 1677. Judge, if it's possible to move this to next week, if there's a miscellaneous court date, what is at issue here is that Mr. Brown, this is actually an older case, notwithstanding the court case number. He served a significant period of time in another jurisdiction in South Carolina, and part of our attempt to resolve this is to incorporate that time into a resolution here. There's a minimum mandatory sentence that's required for one of these particular charges. I'm not certain if we're able to attribute some of that time from the other jurisdiction. We're going to work that out and discuss that, research the issues and see if we can. So I'd ask to set this for 1 week to give us time to do that, Judge.
Okay. Yeah, that's no problem.
Yeah, Judge, just so you know, that the legal issue we need to look up is we did have a hold on him during the time he was in South Carolina. So the legal issue is because there was a hold, can he receive credit towards that minimum mandatory for the time in South Carolina? I think the answer is probably yes, but we need to confirm that before he pleads to a charge with a minimum mandatory, thinking he's going to get credit for that time, so.
Yeah, it's very important whenever we're entering in any type of plea agreement that everybody, most importantly the defendant, is very clear about what you're agreeing to, and you're doing so freely. So in order to get these legal issues squared up, it's important that everybody make sure they're on the same page on that. Do you understand? So we will continue this until May 16th. I think it's a good idea. If you make sure and get this legal issue resolved.
Thank
Court
you.
will continue to May 16th at 9 a.m.
The next one I have, Judge, is Sean Coy, 22 CF 32 and 22 CF 161. Judge, Mr. Coy is actually with the federal government in custody. I think he's serving a prison sentence there.
We don't normally have that way you describe it, with the federal government.
I was trying to be diplomatic. He's at issue here is the felon and battery. We're just trying to make sure that the state's in compliance with Marcy's law. I think they're trying to verify as to a possible resolution. I'm not certain when you want to move it to.
Judge, can we approach
You may.
just because it has to do with some.
Sure.
That Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in
June 15th. What are we looking like on between 15th and 20th as far as numbers in the morning? Just don't want to load one up. Okay. Well, let's do it on June 20th. We'll continue until June 20th at 9 a.m.
Yes, sir. The next one on the docket is Paul Greiner. He is present.
Now, I have an added non-inmate, Haley Bryant, that has yours. And just,
Judge, if we can, she actually contacted me this morning. She was having transportation issues. If we could pass her to see if she's able to. I did speak with her to try to get her to be here because she was not.
That's fine. Thank you.
Paul Greiner is before the court on 21 CF 2041, 22 CF 1349, 22 CF 1980, and 22 CF 2273. Judge, in the interim from last court date to now, we had attempted to get him into a particular substance abuse treatment program. It was not possible to do that. It's not going to be a possibility. So what I'd ask to do, if we can set him on the next we can set him on the next pretrial conference. I think that's 6/14.
Correct.
And it will be this will be the last continuance. So it'll either be resolved that cycle or it will be a trial that cycle.
Okay. State okay with that? We'll continue to the regular pretrial June 14th.
I believe Mr. Greiner is still trying to find the treatment program. If not, then we'll be ready.
Okay. Very good. We'll come back, continue until June 14th at 9 a.m.
Next one I have, Judge, is James Little. He is present and approaching. It's 21 CF 1961. Judge, this is a plea. This will be a plea to a lesser included offense of sale, manufacture, deliver. Be adjudicated guilty. Placed on 4 years of probation. Assessed $11.40 in court costs. $150 cost of defense. A $40 per month cost of supervision, and he has to provide proof of completion of the substance use evaluation and random urinalysis. With respect to the substance abuse, he's actually been in an inpatient treatment program for an extended period of time, and he's gonna provide proof of that to probation. Let me approach Judge.
Is that state in agreement?
It is, Judge. This is based on a legitimate uncoerced plea.
So this is a downward departure?
A plea to a lesser included judge.
Okay. It's a plea to a lesser included judge. I believe the state will provide a score sheet later.
That's correct.
Okay. Very good. Mr. Little, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay, so you heard your attorney state the terms of the plea agreement. You're pleading to a lesser included offense of sale manufacture. You're being adjudicated guilty on that lesser charge. Do you understand that?
Yes, Your Honor.
And you'll be sentenced to 4 years of probation, court costs, obviously importantly, maybe most importantly, proof of completion of the substance abuse evaluation and treatment. And you're in agreement with all that? You believe it's in your best interest to enter into this plea agreement?
I do, Your Honor.
You understand that by entering into this, will be a final resolution of your case, and you're giving up some legal rights by entering this, the right to go to a trial, confront witnesses, etc.
Yes, Your Honor.
You believe it's in your best interest to do that?
I do.
And you've had all your legal questions answered?
I have, yes, sir.
Based upon that testimony, the court will accept your plea to the lesser included offense of sale, manufacture, or delivery, being adjudication of guilt, 4 years of probation, court cost as contained in the plea agreement, which I see you have signed. And I assume you've gone over this plea agreement in detail with your attorney?
Yes, Your Honor.
And obviously, importantly, you need to provide the proof of completion of the substance abuse evaluation and treatment, and there'll be random urinalysis during the probation. Okay?
Yes, Your Honor.
Thank you.
The next one, Judge, is Marlon Marshall. There's a waiver of appearance in the file on Mr. Marshall. I've spoken with the states. If we can move this to a pretrial, I anticipate this will be a plea, Judge.
Okay, we'll continue to June 12th at 9 a.m.
And the next one, Logan McPherson, there is also a waiver of appearance in his case. I've spoken with the states. They've amended their offer to a misdemeanor with administrative level probation. My client's out of state. I anticipate we'll resolve that by written plea agreement before, but at a minimum by June 12th, Judge.
Okay, so we'll continue to the regular pretrial on June 12th.
And I will stand by and see if Ms. Bryant shows up, Judge.
Okay, very good. Mr. Gates, you want to do a couple years?
They're in custody, Your Honor. So,
got to do those two.
I'll take first Mr. Gallo.
Mr. Gallo.
Henson and then Jones.
Mr. Gates, who are you calling first?
Michael Gallo. Your Honor, this is Mr. Michael Gallo before the court in 21 CF 2220. At this time, we're going to enter a denial on the violation of probation and ask the court to continue the VOP to June the 15th. That is his arraignment date for his new law violation.
Very good. Court will enter the denial and continue the case to June 15th at 9 a.m. You want to do it? Want to do it at 1:30?
Yes, Your Honor. 1:30.
We'll do them at 1:30. That's the same as your arraignment time for your other case. We'll do these two, Mr. Catalanic, and then we'll do yours. Are you ready?
Yes, sir, I am.
Okay.
Judge, take his time.
Mr. Gates, he's just got two coming in, and then we'll do you.
It's all right.
Your Honor, this is Pamela Henson before the court in a bond hearing.
You may proceed.
Yes, Your Honor. The current bond is, I do believe, $20,000 cash or professional. I have 10,000, but I was unsure. We're asking the court to set $1,000 or at least the lower bond for Ms. Henson. She has significant ties to the community. She does have an associate's degree, a job. We did put in there the prior failure to appears. When I went back and looked at those, both those were ultimately recalled. On the score sheet, it does not indicate that she has actually been sentenced or pled to any failure to appears. There is, and I spoke to the state about this, it appears that this incident occurred at a time when Ms. Henson was going through some medical issues. I've requested the CAD reports for this address, and a couple days prior...
less than 24 hours, he came in on me.
There was a couple instances. One of the instances, the reports indicate that the neighbors were concerned about Ms. Henson and her behavior. She was acting out of the ordinary. She was twerking in the street and barking at people. The neighbors were saying that's unlike her. She's very nice, very respectful. It appears that a subsequent call out for a welfare check resulted in her going to the hospital where she did receive treatment. She was released essentially.
Sodium level was dropped to nothing. It wasn't a mental health.
Essentially released the next day, and at that point there was an incident between her and the alleged victim in this case, which left Ms. Henson in fear. That night these alleged texts were sent. I'm still working on gathering a lot of that information. I do have just the generic CAD reports, which just give a kind of a generic report about instances at that case. Ms. Henson is simply asking the court to set a lower bond, allow her.
Same ID, same address since I was 15 years old on my identification.
To allow her to get back to work, to support her family, and begin to fight the case and help me with that evidence.
Judge, I would be inclined to stipulate that this is not her first rodeo. She has prior batteries, one being a felony battery in 2016, another in 2020, which was a DV battery. In addition to that, she has an assault on a Leo charge from 2020, and then there was a case where she violated an injunction for protection and also made harassing phone calls to a victim, which
my husband
has similar echoes of this case, Judge. I do think that the bond is appropriate, given the circumstances and given the background here. And the victim has been contacted. The victim was unable to be present today, but the victim has expressed that he is opposed to the bond being reduced.
What's the situation with regards to her any medication she's on, dealing with the mental health evaluation?
None. I've recently.
Talk to your attorney. Don't talk to me because I want.
Oh, yes, sir. Oh, yeah, I absolutely would appreciate having pretrial service. I requested them personally. They were a great asset to me in the past. And
my question is, what is currently being done? In other words, is she on meds?
My sodium level dropped to nothing.
Your Honor, and that's where I'm still working on trying to get some of the medical records from the hospital to verify what actually happened. As I said, I know that there is some evidence to suggest that Ms. Henson was going through some sort of medical issue which directly affected her behavior based upon what the neighbors are stating. Part of the bond.
My sodium level dropped. Just
He can hear you, Ms. Henson.
Okay. My sodium level, sir, dropped to nothing.
And she is part of mental health pretrial services. Has interviewed her as well, and that's something that would require her to take any sort of medication that's prescribed to stay up with treatment as well as someone else kind of keeping track on her as well. She does have another address she could stay at until the resolution of this case.
License since 15. I got my license when I was 15, sir. It's the same address as on my license today.
You know, if I would consider lowering the bond, there would have to be, we have to get a clear picture of what's being done medically.
Yes, sir.
Because there appears to have been something, I mean, if you can confirm medically that it was based on lower sodium, then great, let the court know that.
Yes, sir.
I don't know if that's correct. I'm telling you straight, ma'am, but
It
if
is,
that
sir.
is, we need medical, and we need mental health that they're going to do. Is there some medication she's supposed to be on? Is there something can be done? I'm just not going to,
Yes,
you
sir.
know, the definition of insanity is doing the same thing over and over again, expecting a different result. I'm not going to just release you and you're having some issues, or you need to have some coordination and you're not getting that. So,
Yes, Your Honor.
is there some way we can
Yeah.
have I mean, if she's not on anything in the jail, it wasn't clear really.
They held me
There
for
were
3
some
days.
issues, some indication,
Psychiatric ward,
some
and they
vague
released me
references, but
with
not,
no medication.
hey, here's what we can do if we have mental health, you know, if they're under mental health.
Yes, Your Honor, and that's the conversation I've had with her. We're trying to get the medical records. Unfortunately, I wasn't able to get them before the hearing. I know that there was some, as far as mental health, that the jail is concerned, she's not on any medication. They haven't had any concerns with her mental health issues on that end. They're simply asking for, I think it was the first appearance judge that suggested mental health pretrial services and an eval, hence them being added as a condition of the bond.
And I requested pre-trial mental health.
You know,
Yes, Your Honor.
there's a real lack of clarity, and I'm hearing the state saying that there have been some issues. We can't just keep rolling this out and having these types of issues if they.
Yes, Your Honor.
So I think there needs to be more clarity on the part as far as if there is an eval, that some specific kind of course of action that perhaps, I'm not suggesting it, and you're uncomfortable, but at least make the state more comfortable that we're not just releasing and having more issues. We don't want to have something else coming up and you being arrested.
It's not mental health, sir. But I did request, just so you know, I requested Jennifer in pretrial services and mental health services.
Okay.
Just to ensure that everything is fine. I can tell you for sure, my sodium level dropped the day before they gave me the sodium, released me. On the second time, because it was so severe, they, for 3 days, held me in the mental ward there at the Fort Walton Beach Hospital, and they released me with no medication and a clean bill of health. That I can tell you, and I don't lie to the court ever. I'm not going to insult your intelligence like that.
I understand that, man, but when he gets to these medical issues, they can become quite complicated.
Now I realize.
I know you know a lot about your.
Well, now I realize that I need some medical. I need to address some medical issues. Is what I need really desperately.
Yeah. So I'm going to continue this hearing.
I'm going to bail out,
make a
sir.
decision until we get some clarity.
Yes, Your Honor. At this time, Your Honor, if the court's inclined to do that, Ms. Henson is scheduled next week for arraignment. I'd like to, if we can, enter a not guilty plea on that, and then I'll work on getting some information for the state as well as the court.
Okay, and then we'll come back on just on a regular pretrial on June 14th.
Yes, Your Honor. And then if I get that information, I'll move her up. If
I've
she's
signed the releases.
Okay, and we'll go ahead and enter a not guilty plea on her behalf. Okay. One of the most, I'm listening to what the state's saying, is one of the most challenging situations is the intersection of past action versus mental health. That's some of our most difficult decisions. Anyway,
Yes, Your Honor.
Mr. Gates.
This is Ms. Jones before the court in 23 CF 422. She is scheduled for a bond hearing after speaking with the state this morning. I'm anticipating a stipulated bond on this. Essentially, it would be $1,000 cash or professional signature, or $1,000 signature bond per count for a total of 2,000 signature. There is mental health pretrial services. She's to take medication prescribed, comply with any doctor's orders or recommended treatment. I emailed the state about the GPS and the house arrest. I think those are the two we were going to ask to take off, but everything else would remain the same.
I haven't seen your email. When did?
About 20 minutes ago.
I apologize. Yes, Your Honor, what he's saying is accurate. The state is willing to stipulate to a bond. I believe we agreed to a $2,000 signature bond in this case. I've spoken with the victims and they are on board as well, seeing as we generally, the position of the victims is that this was a mental health issue. So we're trying to be more outcome oriented in this case. That being said, I think that there is a remaining issue as to the GPS monitor and house arrest, which was set by Judge Schlechter when this went to first appearance.
Would that continue or not?
My conversation with the state was that we would take that off and let her have the mental health pretrial services. Her mother is also present to ensure that she does come to court and is complying with that sort of stuff as well.
And to clarify, I am in agreement with that, but I just wanted to make the court aware.
Thank you. No, that's fine. I'm okay with it as long as you all have worked out the details. One thing we want to make sure and have a good plan so that you're clear and everybody's clear with you and you're clear yourself what you have to do with pretrial services. Maybe show up for appointments, following through, and the different things. So with the pretrial services as a condition of the bond, the court will reduce the bond to a $1,000 signature bond times 2, so it's a total of the two $1,000 signature bonds. Okay? Sure, you'll get together with pretrial services to go over in detail what all the requirements are. Okay? Anything?
No, Your Honor. Thank you for your time.
Okay.
When are we setting this for?
I'm sorry?
When are we
She's
setting?
currently scheduled for June the 14th. I'm anticipating I'll move to June the 12th.
We'll continue until June the 12th at 9 a.m.
And she's in the meantime being screened, and hopefully will be in mental health court before we get to that date. Your Honor.
Okay, great. Thank you.
Pretrial services and take meds as prescribed, and that's all I heard.
Correct. Mr. Catalini.
I'm sorry. Your Honor, I have one case on the docket today, and it's Mr. Zachary Lee Dispenetti, Dispennetti, 2 case numbers 22-CF-745 and 21-CF-2717. Your Honor, for the record, 21-CF-2717 will be null prost in exchange to a plea to 22-CF-745 as charged. Count 1, POP, misdemeanor. Count 2, resisting officer with violence. On 22-CF-745, there will be a withhold of adjudication on counts 1 and 2. He would have 1 year of probation on count 1, concurrent with the 2 years of probation he would get on count 2. Substance abuse evaluation and any treatment deemed recommended. He has 30 days to get the substance abuse evaluation and to start the treatment within 60 days. If so, 24 hours of community service work. Anger management. May I approach?
You may.
And Your Honor, I have a score sheet for the court if Mr. Catalinic wants to take that. I just took the.
So 2 years probation. I'm trying to read your writing.
Yes, sir.
Yes, Your Honor.
Okay.
And it's 1 year concurrent. It's just not in the plea form with the 1 year concurrent.
Counts 2. Count 1. Yeah, put that in.
Do I?
Put that in there. The count 1. You had 1 year probation concurrent. So, Mr. Dispenetti, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
And the state's in agreement?
Yes, Your Honor, this is the state's agreement.
Okay. So you heard your attorney state the terms of the plea agreement?
Yes, sir.
And those same terms are contained in the written plea agreement?
Yes, sir.
That your attorney was speaking from, and I see that you have signed the last page of this agreement, so question, did you go over this plea agreement in detail with your attorney? Make sure you had all your legal questions answered?
Yes, sir.
You understand that by entering into this plea agreement here today, this will be a final resolution of your case.
Yes, sir.
And as a result of that, you're waiving the right to go to a trial, to confront witnesses, and all those things that important legal rights in order to have a final resolution today of this case.
Yes, sir.
Okay? And you've had all your legal questions answered?
Yes, sir.
And the defense is okay with the score sheet?
Yes, sir.
Based upon that testimony, the court will accept Mr. Dispinetti's plea agreement here today in exchange for the state null processing 21 CF 2717, the two charges in the other case 22 CF 745. There'll be a withhold of adjudication on both counts. And as to the resisting officer, the defendant will be sentenced to 2 years probation on the possession of paraphernalia. You'll be sentenced to 1 year probation. They'll be concurrent, so it's a total of 2 years. You'll have the standard costs and fees that'll need to be paid during the course of the probation. Okay?
Yes, sir.
You want to just, and importantly, I skipped one, sorry. Substance abuse evaluation. Within 30, start treatment within 60. That's probably the most important thing on this.
Yes, sir.
Okay. Very good. Thank you.
And Your Honor, if I may, just one thing. He lives in South Florida. Is that
Yes.
right? What county? Lee. Your Honor, can he have his
Dade?
Lee County.
Lee County? Okay. That's better than Dade.
Yes.
No, you just have to work with probation. It's much easier actually to transfer probation, even though it's a long way away geographically. It's within the same state. So they'll just talk with your probation officer about that, and they'll explain what it needs to do to transfer. It should not be a problem within Florida.
Yes, sir. Thank you.
Okay? Thank you.
Your Honor, I was with Judge Hillier this morning.
Okay, thank you.
Good morning, Your Honor.
Good morning. Now, which court got preference over this one today?
Your Honor, it was Judge Hilliard over in Milton, which, yeah.
That's all.
They moved the courthouse. It takes me a little bit longer to get there. Your Honor, Chris Garrett on behalf of Austin Clarkson. He has 2 violations of probation, 22 CF 2055 and 22 CF 550. Your Honor, the offer in this case is bars to bed Keaton. Mr. Clarkson has been evaluated for Keaton. We don't quite have that evaluation back yet. If we could leave him set for May 16th, we're hoping to get this case resolved.
State?
That's the state's agreement and understanding, Your Honor. I don't know that we'll have the evaluation back, but we can advise the court at that time where we are, hopefully.
Okay. So we'll try it on May 16th, and if we can get done, or if not, we can do it on June 15th. But you want to try 16th, see if we can get it done?
Your Honor, we can try for the 16th.
Okay.
Hopefully
So we'll continue to May 16th at 9 a.m., and hopefully we can get some resolution. Okay?
Thank you, Your Honor.
Thank you.
Welcome.
Is he not? But yeah, let's go ahead.
Oh, yes, Your Honor, we did
Let's go
enter
ahead
denial.
and enter denial?
Yes, Your Honor.
Okay, so court will enter denial. Thank you, Madam Clerk.
Thank you, Your Honor. Have a good day.
Okay. Ms. Merriwood?
Morning, Your Honor.
Good morning.
I apologize, I was in Crestview this morning. Franny Merrifield on behalf of Dustin Faircloth. It's in 22 CF 1691. There is a waiver on file. We filed an unopposed motion to continue yesterday. We believe that the state...
Sorry.
It may be under my partner, Mr. Flaherty.
There it is. Okay, I have this as already being continued.
Thank you, Judge. I just wanted to make sure. I believe it's on the docket for May 23rd at 1:30.
I'm not sure. Yeah?
Thank you, ma'am.
May 23rd at 1:30.
Thank you, Judge.
Okay.
That's all I have.
Thank you. Appreciate it. Okay. Yep, let's do it.
Morrow for Mr. Booney, Your Honor, B-U-N-I, is 20 CF 1983.
Okay, hold on, let me find the case. All right. Okay. Would you announce the case again?
I will, Your Honor. This is Jose G. Booney, B-U-N-I, 20 CF 1983.
Very good.
I believe this is first time up for Mr. Booney. We'll enter a denial on the record. I don't want to back up your May 16th date, but I have been presented with the state's offer today. If the court would allow me to set it on that date, if it's not too backed up, I'd like
that's
the
fine.
opportunity.
May 16th, we still got slides. May 16th at 9 a.m.
Thank you, Your Honor.
Next, Malik Caproni.
Ryan Morrow for Mr. Caproni, Your Honor. It's 21 CF 1597.
Did you say Crumbs?
Caproni. This is going to be a negotiated plea for the VOP, Your Honor. The agreement of the parties contemplates that we'll be asking the court to revoke and terminate the probation, sentence Mr. Caproni to 4 months county jail with credit for all time served, all counts concurrent, $100 VOP fee, $150 cost of defense, all financials to reduce to a lien after 1 year. I'll pause, give Mr. Caproni an opportunity to sign. And these are misdemeanor matters, Your Honor. We need no score sheet.
The state in agreement? Is that the state's?
That's the state's agreement.
May I approach, Your Honor?
Mr. Caproni, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So I see you just signed the plea and sentencing agreement. Have you gone over this? Hopefully it's not the first time you saw it. You've gone over this plea agreement with your attorney in detail? Make sure you had all your legal questions answered?
I have all my questions answered, yes, sir.
Okay. And you're satisfied that this is in your best interest here today?
Yes, sir.
You understand that by entering into this plea agreement,
Yes, sir.
this will be a final resolution of your case, and you're waiving the right to go to a trial, confront witness. You have some valuable constitutional rights you're waiving to enter into this plea today.
Mm-hmm.
You understand all that?
Yes, sir.
And you've had all your legal questions answered by your attorney?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea agreement. The court will revoke and terminate probation. The court will sentence you to 4 months in the county jail for each of the 2 charges. You will get credit for all time served, and these will be served concurrently. So it'll be 1 4-month term after deducting all the credit for time served. Got the fees and costs that are contained in the plea agreement are required to be paid. They have to be paid within 1 year, or they go to collections. Okay? Any questions?
No, sir.
Thank you. There is an adjudication of guilt on both charges. Thank you.
Thank you, Your Honor.
Thank you.
Israel Chartrand will be next.
Ryan Morrow for Mr. Chartrand, Your Honor. 2 matters before the court this morning that are both VOP, 22 CF 2721 and 22 CF 3012. It appears that this may be a first time up for Mr. Chartrand, so we'll put a denial on the record at this time if that hasn't already been done. I've been presented with the state's offer. Similarly to Mr. Booney, I'd ask the court to allow me to put this on our May 16th date so I can advise and follow up with Mr. Chartrand.
Very good. Court will continue this matter, accept the plea agreement, the plea of the denial of the violations of probation. We'll continue the matter to May 16th at 9 a.m. to give you a chance to go over the offer with your
Thank you,
attorney.
Your Honor.
Irene Clinton.
Ryan Morrow for Mr. McClendon, Your Honor. We have 6 matters before the court for Mr. McClendon today. I'm asking the court to allow me to continue this to our June date.
You want to go ahead and announce the 6 cases? You want me to give them? 18 CF 2721, 18 CF 3060, 18 CF 3061, 18 CF 3062, 18 CF 3063, and 18 CF 3064.
Thank you, Your Honor. I'm having Mr. McClendon evaluated for Veterans Treatment Court. I've not heard back from them, but I did get confirmation from Mr. Rivera that he was aware of my request. So I'm not intimately familiar with how long.
So do we need to go ahead and enter a plea here today?
Oh, we'd like to enter
a denial. And how long do we need to continue this to, come back on the 15th, or?
I'm happy to come back on the 16th, Your Honor.
If you don't
I don't know if we'll have an answer or not. This is my first go around with Veterans Treatment Court in Okaloosa County.
I mean, I'll do it either way. I don't want to just do it if we know it's going to take longer than a week. A week is a pretty short time frame.
Your Honor, we may be able to get him evaluated for vet court by next week. I don't know if we'll have an answer whether the state attorney who
Why don't we come back on June 15th?
does vet court will accept him.
Okay.
That'd be fine, Your Honor. We appreciate that.
June 15th, Max? No. Sure.
Thank you, Your Honor.
Taylor.
I'm glad you're trying to take advantage of some of these specialty courts if they apply. So that's good.
Yes, Your Honor. And I staffed vet court in Escambia for a while, so I'm a big fan of that program.
Yeah, it's a very positive program.
This is Mr. Darren Taylor, Your Honor, 22 CF 1746, 21 CF 250, 19 CF 2910, and 22 CF 2182. We'll enter a denial for the record if that hasn't already been done. It appears it may be a first time up for Mr. Taylor. I would ask for the May 16th date. I don't know that I've seen the state's offer in this case yet. We have a new prosecutor in the division, and I'd ask that if we can have that date, we'll bring this in.
Has there been an offer made on this?
There is not, Your Honor. My deadline to send discovery over and make an offer is going to be May 12th. So we're coming up on it. It will be sent soon.
Okay, so you think we can get it back by May 16th?
We'll be having a conversation before then, Your Honor.
I just want to make sure we didn't just put it on front.
Yes, Your Honor.
Okay, so we'll come back May 16th, 9 a.m. Mr. Merrill, I think you've got a couple of out of custody. Announce those and see where we're at with them. The first one I've got is, Derek. Is it Gomes?
Or Gomez, Your Honor, I'm not sure. This is 21 CF 2890, 23 CF 216. I had called out for Mr. Gomes earlier in the proceeding. You have Mr. Gomes?
Yeah.
State?
At this time, the state would request a capias.
Correlation and no bond capias. Next is Sonia Greco.
Ryan Morrow for Ms. Greco, 22 CF 2564. I had called out for Ms. Greco earlier. Do we have Ms. Greco?
State?
Judge, the state would ask for a capias at this time.
Court will grant and no bond capias. I think that's all you got there, Mr. Merrill.
May I bring up another matter for the afternoon docket, Your Honor?
Sure.
It's Mr. Anthony Griffin. I had filed a motion to continue. I'm still waiting on some.
2:30?
It was, Your Honor.
Hold on.
Two cases.
Hold on. Yeah, I did look at that yesterday. Looks like it's unopposed.
Yes, Your Honor.
Which case is this?
This is Griffin Anthony Griffin, it's at 2:30 this afternoon. It's two cases, 22 CF 1240 and 22 CF 2457.
That's correct, Your Honor. I did not oppose that motion.
Okay, and what are we continuing it to?
Our June date would probably be best, Your Honor. I expect I'll have what I need by the end of the month, but I'll still need to review and confer.
So you want to put it on the miscellaneous on June 15th?
Yes, Your Honor,
What do
please.
you have in the afternoon on June? Well, we definitely don't want to do it then. June 20th is fine. Okay, June 20th will be fine.
And that'll be at 2:30, Your Honor?
Correct.
Thank you. I believe that's all I have for both this morning and the afternoon.
All right. Very good. And catch up on all the other stuff you got to do, right? Okay.
Your Honor, in the back, is Timothy Henderson is waiting on Dustin Durrell.
I think Mr.
I'll let him down.
Mr. Durrell had court in Santa Rosa communicated. He's on his way, is my understanding. We'll be here for a plea today, and the victims are present.
Okay. Why don't we, let's see, if there's any others, let's see. I think that's the last case we have this morning. Correct? What we'll do is we'll just adjourn, and the bailiff got my number, and I'll come as soon as Mr. Durrell arrives. Does that work? Okay. There, we're good. Gates, Mr. Medina, we're all.
I think Ms. Sharpless is going to try to reach out in Mr. Kabbalah's case to the alleged victim, and maybe we can resolve that. You want to wait till 1:30 on that? Okay. Then I'll just return at 1:30, Your Honor.
Okay.
Thank you.
Very good. We'll all be standing by.
All rise, please.